This is Chapter 2, Part 3. Chapter 2, Role of the Courts, Part 3. We're spending more time because this is a very foundational chapter. It's important to go over this stuff. Let's look at your textbook, page 40. Second paragraph. It's not unusual for the appellant to successfully establish that an error occurred in the trial, but still lose the appeal. And I already mentioned that. That's because of the harmless error rule, which is based on the premise that errors occur virtually at every trial, and a case would only be reversed if an appellate court is convinced that the errors contributed to the verdict. Okay. Well, let's go ahead and look at the bottom of that same page, page 40. Under the U.S. view, double jeopardy bars a retrial only if the case was reversed due to insufficient evidence. If the appellate court ruled that key evidence is inadmissible, it is unlikely that charges will be refiled. But if there was a more technical error, the prosecutor would probably refile the same charges, or maybe a lesser charge. At the bottom, only a small portion of defendants who win their appeals actually go free. Slide 21, appeals to the Supreme Court. Usually can reach the Supreme Court only after exhausting all other appeals. A file asking the court to issue a writ of cert. A writ of cert is an order from a higher court to a lower court requesting its records. And granting a writ of cert means the court will hear the appeal. Slide 22, appeals to the Supreme Court. Other petitions, you can have a waiver of formalities, a friend of the court, a petition in favor of one side. Hearing the case, a court hears oral arguments from opposing counsel. The majority then writes its decision or opinion. Page 41, last paragraph. The process of requesting that the U.S. Supreme Court hear a case is referred to as a petition of writ, and it's frequently accompanied by a request to proceed, and that request is to obtain a waiver of some of the formalities. Let's look at slide 23, habeas corpus. And let's start off with habeas corpus on textbook page 42 at the bottom. Habeas corpus is a civil lawsuit filed in the trial court to challenge illegal confinement. Being in jail, in prison, or on probation or parole due to an improper conviction fits in this category. So does failure to release an inmate after the sentence is completed and involuntary confinement of a mentally competent person in a mental health facility. So if someone is in jail and they shouldn't be, they have an improper conviction that's been proven, or they're being confined and they've been found innocent and they haven't been released yet, or they're in a mental health facility and there's no need for them to be, then a habeas corpus case would be filed. Top of page 43, that can be filed whenever the situation merits, before or after trial. A judge can order that the person be released from custody or the conditions of confinement be changed. A conviction cannot be reversed or monetary damages awarded, though. Just below that, let's look at examples that should be raised by habeas corpus. A person was illegally arrested and being held in county jail. A person was placed in a mental hospital against his or her will, and they are legally sane. A person has served his or her entire sentence, but they've not been released even though they served their time. A defendant's Sixth Amendment right to an attorney at trial was violated because the defense attorney was incompetent. So those are issues that could raise habeas corpus. Now, does that mean that people that are in jail can just file habeas corpus saying, you should let me out? No. And I believe we talk about that in a moment. So, yeah, we will. It's a civil lawsuit, so slide 23, challenging the right of the government to hold a party in custody. It's used for an illegal arrest, a failure to release someone, or a lack of counsel. It's not a criminal right, it is a civil action. And Congress has limited it, however. Anti-Terrorism and Effective Death Penalty Act of 1996 limited it. Let's look at the top of page 44, the first main paragraph. Starting around 1975, state inmates began filing habeas corpus to be demanded to be released from custody. And it became so widespread, there were so many meritless cases, that Congress passed the Anti-Terrorism and Effective Death Penalty Act of 1996, which restricts state inmates' access to federal habeas corpus. Slide 24, Civil Rights Act. The Civil Rights Act of 1871 was filed, and in the section 1983 applies when state, county, or city officials deny a citizen their civil rights. It applies if government officials are not involved. the Bivens case, a lawsuit was filed against federal officials for civil rights violations. Slide 25, the Bivens versus 6 unknown federal narcotics agents. Federal narcotics agents searched a home without a warrant and they arrested Bevins. After charges were dismissed, Bevins sued the agents, claiming a violation of his Fourth Amendment rights. The Supreme Court recognized a new course of action, Bevins, when federal agents violated his Fourth Amendment right. This is a civil, not a criminal remedy. Page 46 of your textbook. Let's look at examples of cases that can be filed under the Civil Rights Act. Police use excessive force when making an arrest. Police conduct extensive search that violates the search incident to the arrest. Police violate Miranda when interrogating the suspect. Filthy, unsanitary prison conditions that violate the Eighth Amendment of cruel and unusual punishment, and failure to provide competent attorney for indigent defendant at a criminal trial. The Supreme Court, the first main paragraph, has a historical perspective when deciding who should have immunity under the Civil Rights Act. This results in 2 types of immunity largely based on job function. Absolute immunity applies to judges and prosecutors when acting in their official role, regardless of their state of mind. Regardless if they step out of their, or when they step outside this role, they have qualified immunity. A witness has absolute immunity while testifying before a grand jury. Absolute immunity means a Civil Rights Act case would be dismissed if filed against them. Most other state and local government employees have qualified immunity. If it can be shown that their actions were taken in good faith, the case will be dismissed. Top of page 47, examples of cases that have immunity under the Civil Rights Act. Officer conducted a search that violated a rule established in a very recent Supreme Court decision. They have qualified immunity. Officer in good faith thought there was a probable cause for arrest. Qualified immunity. Prosecutor maliciously, purposely and maliciously filed criminal charges. Doesn't matter. He or she has absolute immunity. That next paragraph, the 11th Amendment prevents suits against the state and state officers and their official capacity from being heard by the federal courts. So there is protection especially for judges and prosecutors, but for officers and government employees when acting in their role. And that's it. Finally, we're done with chapter 2.